everyone for coming along this morning, and we've just started recording the event now. I'd like to begin by acknowledging the Wadi Wadi people of the Dharawal country, upon whose ancestral lands I'm situated today. I'd also like to pay respect to elders past, present and emerging, and acknowledge them as the traditional custodians of the knowledge embedded in this land, and also acknowledge that their sovereignty over the land was never ceded. I'd also like to invite you, recognising that in this online forum we're located in different First Nations country, to encourage you, if you would like, to acknowledge the country that you're situated on in the chat, if you would like to. So welcome to COVID-19 and Sites of Confinement. This panel forms part of the Law and Society Association of Australia and New Zealand's annual conference program of events. We're very excited to have such an amazing lineup of speakers, and I'll be introducing them in a moment. But first, I wanted to just extend our thanks to all of the speakers for being involved today. It's a busy time of year, and we're very grateful to have your contributions, your first-hand contributions on such an important and timely topic. I also wanted to quickly thank Dr. Trish Luca, the convener of the LASANS, as we say, as an acronym, conference committee, and also president of LASANS. And congratulations for her renomination yesterday. And so thank her for all of her work organising these events, and also thank the rest of the conference committee and the research assistant, Tina Huang, for their contributions as well. And I just also wanted to note, because this event forms part of a larger program of events, you might be interested in having a look at the other events, which you can find on the page where you registered. And in particular, there's a related event on this afternoon, starting at 12 o'clock, on immigration and the intensification of borders during COVID, which I understand Marty and Sarah are involved in as well. So please note, this event is being recorded, so just take that into account in your discussions. And also, we would ask if you can mute your microphones while the speakers are presenting. If you have any questions during that discussion, please pop them into chat. We will have a question time at the end. But we do encourage you, if you can, to leave on your cameras so that we can see everyone who's zooming in today. So the structure of the panel will be that Sarah and Claire will introduce the context of the panel, why now in terms of COVID, and why are we bringing together immigration, detention and aged care, which might seem like quite disparate contexts and sites of confinement. We'll then hear from each of our three lawyer panellists who have been involved in litigation related to COVID, in relation to these two sites. Then we'll have broader reflections by our two discussants who are involved in activism and scholarship related to the theme of the panel. And then we'll have time for questions at the end. And if you do have any questions now, you can, or comments, please pop them in the chat. So I'd just first like to introduce each of the panelists before we move on to commence the formal parts of the panel. So first, going to our lawyer panelists. Marty Verma is an accredited specialist in immigration law and has practiced exclusively in that area since 2010. She's a senior lawyer at Clothier Anderson Immigration Lawyers, where her practice focuses on litigation, cancellation matters and cases involving immigration detention. Marty also works as an migration lawyer with the United Workers Union, and is the Deputy Chair of the Visa Cancellation Working Group, which is a national network of organisations focused on visa cancellation and detention. John Karantzis is a personal injury law and litigation plaintiff lawyer, and he specialised in that and worked in that area for over 20 years. He practices in Melbourne with a particular focus on work injury and transport accident law. He's accredited by the Law Institute of Victoria in personal injury law, and is the chair of the Law Institute of Victoria Work Cover Committee. Thirdly, David Burke is legal director of the Human Rights Law Centre's Asylum Seekers and Refugee Rights team. This team uses strategic litigation and advocacy to fight the worst aspects of Australia's cruel refugee policy of deterrence. This work has included urgent federal court cases for men, women and children in Nauru and Manus to allow them to access medical treatment, and also more than 200 High Court proceedings to prevent the return of more than 550 refugees and people seeking asylum to offshore detention. Our discussants, first we have Stephen Caruana, who is coordinator of the Australian OPCAT network and is also involved in monitoring aged care facilities and designated mental health units in New South Wales. Stephen was formerly a detention inspector for both the Inspector of Custodial Services in Western Australia and the Commonwealth Ombudsman. Stephen is a Churchill Fellow and the Australian Ambassador for the Human Rights Measurement Initiative. Our second discussant, Dr. Claire Spivakovsky, is a senior lecturer in criminology at the University of Melbourne, and she's interested in challenging the role of law and legal processes in the ongoing segregation and coercive control of people with disability within what is claimed to be a deinstitutionalised community. As such, much of Claire's work focuses on the use of violent, restrictive and coercive practices in community settings such as group homes and schools. She's the lead editor of a number of edited collections, including The Legacies of Institutionalisation, Disability Law and the Deinstitutionalised Community, and Critical Perspectives on Coercive Interventions. And lastly, our facilitators for today, Dr. Claire Loughnan is a lecturer in criminology at the University of Melbourne. Her research focuses on the externalisation of refugee protection and on the modes, practices and effects of sites of confinement, from immigration and youth detention to prisons and disability and aged care. She's the University of Melbourne branch co-convener of Academics for Refugees and a research partner with the EU-funded comparative network on the externalisation of refugee policies. Dr. Sarah Dam is a lecturer in international law and refugee law at the Faculty of Law, UTS. Her research focuses both on the international administration of human mobility and the changing forms and practices of border controls in Australia's refugee detention regime. And she's also a national co-convener of Academics for Refugees. And very lastly and quickly, I'm Linda Steele. I am a senior lecturer at the Faculty of Law, UTS, and I am a socio-legal researcher working at the intersections of disability law and social justice, and have recently completed leading a project funded by Dementia Australia Research Foundation on human rights and people with dementia in aged care. So I'll now pass on to Sarah, who's going to set out some of the context for today's panel.
Great, thanks Linda. I too would like to acknowledge that I'm zooming in from the unceded lands of the Gadigal people of the Eora Nation, and to pay my respects to elders past and present. I also note that Indigenous peoples are impacted by the topics that we're discussing on this panel today. Indigenous people have been detained in Australia's immigration detention, and the Australian government has in the past knowingly sought to forcibly deport people who are members of First Nations communities in Australia. Likewise, Indigenous peoples are also residents in aged care facilities across Australia and are disproportionately represented amongst the 65 to 75-year-old cohort of this population. This means that struggles for Indigenous sovereignty and justice are also linked with both those of and for migrant justice and also the just care of elderly peoples in our community. Let me now turn to providing some brief context for this panel. The idea for this panel came out of some individual and joint academic and advocacy work that Linda, Claire and I were involved in with many others on the regulation and harms of immigration detention on the one hand, and the regulation and harms of aged care facilities on the other, both pre-COVID and then once the pandemic hit Australia in early 2020. As the state, institutional and community COVID responses unfolded, it quickly became clear that people living in aged care facilities or forcibly detained in immigration detention were both groups at heightened risk of contracting COVID-19 due to the strong likelihood of the virus entering and circulating in such closed institutional settings, both being environments where it is near impossible to implement social distancing or to self-isolate effectively. In addition to this heightened possibility of infection, both groups contained individuals who were at specific risks of harm from COVID infection due to common comorbidity factors such as age, gender, or particular health conditions, or limited access to healthcare. I'll leave it to Claire to speak in more detail about some of the conceptual and regulatory similarities and differences across Australian immigration detention regime and the aged care regime. One, of course, being largely characterised by the racialised logic of border security and exclusion, and the other one more dominantly framed through the language of quality care and service delivery. But I do want to briefly touch upon the general COVID-19 framework that applied to both sides. So across both sites, the main response has been one of outbreak management of COVID-19 prevention and detection that, while important, has also clearly had its limits. Something that we saw, for example, most particularly in the high death rates in the Victorian aged care or in Victorian aged care settings, and that we hope that this panel discussion will also draw out. So this outbreak management response is reflected in the respective sets of COVID-19 guidelines that the Communicative Diseases Network Australia, the CDNA, a joint initiative of the Australian Health Ministers Advisory Council, adopted in March 2020 for aged care settings on the one hand, and prison and immigration detention on the other. And the latter guideline is explicitly based on or influenced by the former set of guidelines. In focusing on measures such as the provision and use of PPE by staff, prohibiting external visitors to facilities, or even enforced isolation practices for suspected cases of COVID-19, this outbreak management response across sites has largely exacerbated experiences of confinement without necessarily offering or addressing the underlying risks of being in closed institutional settings, nor offering adequate protections to people incarcerated in immigration detention or living in aged care facilities. In addition, the preventative protective measures recommended for the general public by government and medical experts, such as social distancing, are precisely those measures which are difficult to guarantee in confined congregate settings like aged care facilities or immigration detention, particularly when both sites are characterised by highly casualised workforces with staff rotating in and out of facilities on a daily basis. Most disturbingly though, the refusal to consider alternative forms of accommodation or care across both sites has enhanced the risks and likelihood of exposures rather than minimise them. And I'll leave it to our expert panellists to speak more about these risks, failures and available alternatives. And so this panel is really an experiment in bringing together different conversations about the stark inadequacies of the COVID-19 responses in immigration detention on the one hand and aged care on the other. In focusing the panel around the possibilities and limits of legal actions and COVID-19 related legal actions in particular, we hope to reflect upon the challenges of achieving institutional justice or law reform on the one hand, or proposing alternatives to institutionalisation or incarceration on the other. And now I'll hand it over to Claire to briefly introduce the conceptual and regulatory similarities and differences across the two sites. Thanks, Claire.
Thanks very much, Sarah. And I want to echo your comments about what the implications of what it means as settlers to live on what are stolen lands in this country and the implications that follow from that. So I want to talk a little bit about why, you know, the kind of intersections between these two sites. And it might seem really counterintuitive to bring together analysis of immigration detention centres with residential aged care facilities. And while immigration detention is purportedly administrative in nature, in practice, detention centres operate much like prisons and are experienced concretely as punitive settings. In contrast, the regulation of residential aged care facilities tends to be focused on ensuring sort of service delivery of care through funding models that are aimed at facilitating quality of life, access and supposedly choice for older people. In practice, however, these largely privately run facilities are segregated from society, offering limited social integration And importantly, we argue that both are sites of confinement where individuals are subject to detention, surveillance, segregation and social isolation. When I say we argue, this is something that's been extensively recognised in much of the literature and advocacy as well. So these are often both places of vulnerability, secrecy and invisibility. As marginalised populations, those held there tend to be kept out of view and may not be conceptualised as part of the general public at large. Both sites can also, as we know, be places of trauma and suffering, characterised by systemic breaches of human rights, which can be range from quite egregious breaches through the use of chemical and physical restraints. In relation to the latter, we've seen recent media reporting of the use of handcuffs in immigration detention, and in aged care we see other examples like the use of bed rails.
Apologies, it looks like we've just lost Claire for a moment. Hopefully.
Everyday restrictions over how interactions with others are conducted, who can visit and when a person can eat, and the extent of privacy. It's intrusive and undermine human dignity and autonomy.
Claire, sorry, you might need to turn off your video because you keep on stopping and starting.
Okay, thank you. So as I was saying, in relation to human rights breaches, these can be quite egregious and quite serious breaches or obvious and violent breaches of human rights, to more subtle and pervasive forms of control. So control over daily schedules, who can visit and when a person can eat, and the extent of privacy a person enjoys. Just as the physical spaces of these sites are kept separate, so too are they typically regarded, considered, theorised and scrutinised in isolation. And this siloing is evident both in scholarship and in practice, including through distinct inspectorates and oversight bodies that bring their own distinct purviews, remit and access. Yet the intersections between these diverse sites have been indicated by 2020 Australia OPCAT Network report, which argued that locked and segregated units in residential aged care effectively operate as places of detention. Those in aged care facilities are subject to limitations on their mobility and autonomy, and especially vulnerable to breaches under the Convention Against Torture. Importantly, many of the existing concerns related to oversight and the produced vulnerabilities of those living in both aged care and immigration detention have been laid bare by the COVID-19 pandemic. Accordingly, when we turn to sort of legal responses and focusing on legal advocacy connected to these sites, this might allow a broader application to a range of other regimes of state control, such as quarantine, disability and child welfare. While they appear to be, and in many ways are, quite disparate legal regimes and populations, both sites are marked by jurisdictional, regulatory and conceptual similarities. Both sectors are subject to Commonwealth legislative regimes that set up administrative powers, regulatory functions and oversight mechanisms. As non-criminal sites of confinement control, this sets them apart from custodial prisons and juvenile justice centres, which generally fall under state or territory jurisdiction. There are also important historical parallels across how each federal legislative regime have allowed both sectors to operate. Most notably, they both allow for privatisation, a characteristic which emerged during the Howard years. This introduced a profit motive for both sectors that sits ambivalently alongside service models supposedly offering welfare and humanitarian support. Finally, both regimes are at times justified as purportedly dedicated to the safety and security of those detained or residing there, yet both are marked by the violent loss of autonomy for those held within them. These connections might help us to think through possibilities and limits of legal advocacy strategies to disrupt the structural harms reflected by the pandemic and beyond, especially given state resistance to categorising aged care facilities and immigration detention as sites of control, confinement and violence. Despite these parallels, there have been key differences in the legal action taken to seek redress for COVID-19 risks. And I'm sure that the panellists will draw these out in their contributions. So these different responses in legal action suggest that notwithstanding their convergences as sites of confinement, the adoption of particular legal forms of legal action has been informed by persistent differences between them, including different mechanisms of inclusion and exclusion, not limited to the legal status of these two distinct populations. So it's with these intersections and distinctions in mind that we turn firstly to the forms of litigation in each setting. So I'll hand over now to Linda to convene the next part of the session. And I hope that that worked okay with the internet. Thanks.
Yeah, thanks, Claire. Thank you. We could hear you fine once you turned your video off. Okay, so now I'd like to invite each of our three lawyer panelists to introduce the litigation that they've been leading, explaining the context, strategy, and actual or intended outcomes of this litigation, noting that there are various stages in the process. So I might first invite John, if you could introduce the aged care related COVID-19 litigation that you've been involved in. Thank you.
Thank you, Linda. Hi all. I'll give context of the 3 class actions we have issued in the Supreme Court of Victoria in Melbourne in regards to COVID-19 and the virus and the impact upon, well, people in the state of Victoria. We've issued 2 class actions concerning, one being against St Basil's Nursing Home, the second one being the Epping Gardens Nursing Home, and the third one against the state of Victoria. Now, these all relate to the second wave that Victoria experienced and suffered in basically July of this year, which arose out of the conduct, mismanagement, neglect of the state of Victoria and its managers and so forth in regards to the quarantine and the security guards fiasco, which has been subject to a lot of media coverage and subject to a current inquiry by a former judge of the County Court of Victoria, which is, her findings are to be released in, I think, on the 21st or 22nd of December this year. Now, the 2 class actions against the nursing homes, we've issued a very detailed statement of claim where we allege that due to, in effect, the mismanagement, negligence, and conduct of the operators of those nursing homes, those people, I call them the loved ones that were situated and housed within those nursing homes, many died as a result of the mismanagement and conduct. Many have suffered injury. Many continue to suffer injury due to the conduct, mismanagement of the management at these said nursing homes. Now, we all know basic torts, as in negligence, liability, foreseeability, all those issues come into play. We've had a case management conference with the Justice Dixon of the Supreme Court initially a few weeks ago. One has been set down. Initially it was set down, a further one was set down to give directions as to the management of this proceeding in late December. However, due to the report of the current inquiry being not finalised and not released till late December, that His Honour has decided to adjourn further conduct of all proceedings relating to COVID-19 till early March, 1st of March, and I think the 29th of February there's one. There are multiple class actions in this regard. We also allege that and interestingly, it's not only a tort case, but it is a contractual case, and we allege breach of fiduciary duties by these nursing homes and the operators in the sense that these people had actually signed contracts to live in these and reside in these nursing homes. So it's a high standard. It's a high standard, and also it's a high standard of duties that were owed to these claimants, in the sense that we are talking about the vulnerable. We're not talking about people that were, of sound mind, and there were some people that were totally vulnerable and literally in the hands of these operators. So they were totally dependent on these operators, and it's a breach of fiduciary duty, we allege. Now, WorkSafe Victoria has been investigating the deaths. The coroner has referred the deaths at these nursing homes to WorkSafe for investigation. We've been in contact and liaison with the Victoria Police, because the police is actually doing the work on behalf of WorkSafe on top of WorkSafe inspectors. I know one defendant has asked us formally to agree to a stay of the proceeding to await the outcome of not only the coroner's report investigation, but WorkSafe investigations, because they actually state in their correspondence, which I found interesting, that considering that the manslaughter laws in Victoria, Victorian workplace may now apply, they want to await the outcomes. So we're talking not only civil penalties, but quasi criminal penalties, in the sense that criminal manslaughter charges may now apply against the operators of these nursing homes. And we've formally requested WorkSafe in that regard to investigate that.
Thank you, John. I might just, we might go on now to San Marti, but there's time for reflections in a moment, and we'll certainly pick up on strategic points. And thank you. So Marti, if you could tell us about the litigation you've been involved in, its context and where it's at, and your strategy behind it. Thank you.
Yeah, sure. It's certainly less complicated than John's actions. But look, I'd like to start by acknowledging that I speak to you from the stolen lands of the Boonwurrung people of the Kulin Nation here in so-called Melbourne. And I'd like to acknowledge the primacy of their struggles for sovereignty, and acknowledge and pay my respects to their leaders, past, present, and emerging. And as Sarah said at the commencement of all of this, the strategies that we're speaking about of state control and confinement, given the gloss of public health management, these are strategies, colonial strategies, that were put into effect in the early era of colonisation and have evolved first then in the introduction of so-called reception centres that were intended, in the 90s, 80s and 90s to receive and screen for health purposes immigrants, and then release them into the community, to what has evolved now into full-scale, mandatory, punitive detention. So there is a colonial thread that runs through everything that we're talking about, and I acknowledge it and practice in that context. So we were involved in, and David will be able to say a lot more about, the other kind of series of cases and the sector discussions that happened, but we ran but one humble case, BNL 20, and Minister for Home Affairs. We commenced that action in April. In basic terms, the action was brought in tort, again, as John was talking about, alleging, so what was alleged was a breach of duty of care to our client, who was detained at that time at the Melbourne Immigration Transit Accommodation based in Broadmeadows. And what we sought in the interim was an interlocutory order requiring the Commonwealth to cease to detain our client in that facility on the basis that there was an apprehended tort taking place there. So I'll talk to you a little bit more about the context within which that action was commenced and that action was brought. So I suppose if we kind of zoom out and look kind of globally and politically at the context within which that action commenced. So by the time we all started like scratching our heads as a legal sector in early 2000 and earlier this year, so early 2020, there had already been wide-scale actions commenced on behalf of both prisoners and immigration detainees in both Europe and the US. So in the UK context, there was the case of Detention Action, which is a sort of advocacy body and NGO, acting as plaintiff and secretary for state of the Home Department, where a group of detainees represented by Detention Action alleged, amongst other things, a breach of their rights under the European Charter of Human Rights, that right being not to be held in conditions that were cruel or inhuman in nature. So that was one of the allegations that was made in the course of that, but it was a much broader proceeding that was commenced in March 2020. And then in the US context, of course, that place is a place of, litigation aplenty. But the first case that we all had regard to was Freyhard and Immigration and Customs Enforcement, or ICE, in which a class of people represented or constituted by thousands of people held in ICE custody in immigration detention, basically alleged, amongst other things again, a breach of their rights under the Fifth Amendment of the US Constitution, which is a due process guarantee. And the allegation was that those rights had been breached by what constituted essentially medical indifference or punitive neglect in the circumstances in which ICE was holding them in immigration detention. So I suppose by the time we all attended to this issue, the call of people in immigration detention settings all over the world was crystal clear, which was that first, immigration detention itself is a form of harm, that was rendered utterly clear by COVID-19, and that moreover, strategies to manage and contain COVID-19 in immigration detention facilities redoubled that harm and sort of segmented it into forms of further and more sophisticated harm. So, the use of restraint, the restriction of visits, a sort of increased use of force to enforce social distancing, and then ultimately the use of isolation. So, putting people in the slot, essentially, if they were a suspected COVID-19 case. So that call was all abundantly clear. So that was the background against which all of this began to take place. And how did it practically begin to take place for me? I suppose sitting here in precisely this room where I've been for 9 months, I started receiving calls on my mobile from people who had family members in immigration detention, who had, I feel like people in MITRE, in the immigration detention MITRE, scratch numbers, lawyers' numbers into the walls or something. But you get calls from people that you've never heard of before who said that they'd found your number and maybe they don't know your name. But they started to speak about, this heightened sense of uncertainty and the information lag that they were experiencing in relation to COVID-19, which deeply disturbed people. So this happened all around March. And then I suppose we got together as a sector. David will talk to you much more about that, and to talk about what precisely could be done within the framework of Australian law to address what was a profoundly distressing issue that was going on in immigration detention facilities. There were two looming legal realities that confronted us that did not confront practitioners in the US and the UK. The first being the mandatory status of immigration detention in this country. That is, under the Migration Act, any person without a visa must be detained. That is just a legal reality that pervades our system of law and judicial thinking in this space. And the second, of course, which I'm sure Stephen will talk to you much more interestingly about, is the absence of any external rights frameworks on which to hinge such a challenge. So with all that in mind, with all that in mind, essentially the challenge could only realistically, we thought, be brought in tort. So it was a matter of private law in tort, really. That was the only thing available to us. The framework of tort law has been greatly expanded over the past 5 years in particular by multiple Medivac-related challenges for people who were detained in offshore detention facilities. And so starting from the case of S99, which I'm sure many of you who are lawyers have read, there is a recognition as a matter of Australian law that the court may intervene to grant remedy or at least temporary relief in cases of apprehended tort. So that is where a breach of duty of care is established, but the harm in question is yet to crystallise on the basis that, internationally speaking, tort law recognises that it is preferable to intervene before a foreseeable harm, if the court can at all do that, rather than wait for that harm to eventuate. So the harm in this case, of course, and the harm in offshore detention cases, of course, being death, possible death. So, but, in having recourse to tort law, we also understood that there were profound limitations to the use of tort. So Mustipur is a very famous case from the 2000s. It concerned an Iranian man who brought an action in tort in relation to the conditions of his detention in a particular facility in circumstances where he was held punitively in solitary confinement in that facility, while at the same time he was in confinement, his daughter was wrongfully removed to Iran. So absolutely abhorrent conditions, and he sought interim relief in the form of his release from that particular detention facility. And we all know, or anyone who practices in this space knows, the upshot of what happened in that case. In an interim judgment, the court comprehensively found that the conditions of his detention in that particular facility constituted a breach of duty of care, and the remedy ordered was that he was detained elsewhere, and that's precisely what happened to him. He was taken from one setting of detention to another setting of detention. So we all understood that this was happening. So if we talk about the strategy, I suppose our strategy was to litigate at such a point and in such a manner, with the benefit, I suppose, taking the benefit of state border closures, that albeit that the court did not have the power to order the direct release of our client from immigration detention, that as a matter of actual fact, that is what precisely would occur. And of course, the strategic basis or the strategic framework within which the case was brought, and David will talk to you more about this, was to highlight precisely that immigration detention had become a form of punitive harm for litigants or for people who were detained.
Okay, sorry. And
yes.
Is it all right if we move on to...
Of course. It's so difficult in 5 minutes.
Get a sense of all three actions, is that...
Of course. I'll come back to it later.
Okay, thank you. David?
Sure. So Sam Marty's covered off basically the legal strategy. The context for our work is that we ran a case at the same time that was heard earlier during the first wave of the pandemic. But I'll very briefly just touch on, I guess, the broader collaboration that was part of this legal strategy, which I think is a feature of the refugee sector, particularly in the last 3 years. So what happened was, when the pandemic hit, it was really obvious that there was action needed and that places of detention were high risk. Everybody knew this, yet the government very deliberately chose to take essentially no action, which is particularly egregious in an immigration detention context in which we have thousands of people entirely unnecessarily locked up in the first place. So it is purely a bureaucratic decision to keep them there, and to keep them there at a time when it was known that they were putting their lives at risk. And while we haven't had an outbreak in immigration detention yet, I can assure you that is purely because of luck, not because of any competent management or appropriate political considerations. This was a purely ideological decision, and one that actually actively put people at risk. So when the pandemic hit and it was clear the government wasn't going to take any action, we brought together various legal organisations that work in the refugee sector, and, as Sam Marty said, essentially tried to see what we could do within the really limited legal framework that we have. When it comes to the refugee space in particular, there's been decades now of very overt efforts by the government to limit the role of the rule of law and the judiciary, and to make it as dominated by executive decision as it possibly can be. And we see that in sections of the Migration Act that expressly provide that the court can't actually release someone from immigration detention, which is why we got to a legal strategy that was to seek an order that the government cease to detain an individual in certain circumstances, given that the very logical order that was successfully achieved in other countries, and particularly countries that have protections for human rights in charters and constitutional Bill of Rights, was for release, because that is the simplest solution, and it's actually the only way that you can mitigate against the threat of COVID-19. So from that collaboration between a large number of organisations, there was multiple cases. San Marty and we filed at about the same time, I think. Our case was on behalf of a man who was held in detention in Queensland who had underlying health considerations. And while this would have been about April or May, and San Marty's was adjourned off during that period as the kind of numbers decreased, and then brought back for hearing during the second wave in Melbourne. Ours was pushed to an urgent interlocutory hearing where essentially the federal court rejected the underlying case theory of the idea of this injunction as a negative, the fact that you can order the government to cease to detain someone in that circumstances based on the evidence. That was, of course, more successful later on, and we would say very appropriately more successful later on in San Marty's case. But we were then put on for a final hearing, but at the same time, Queensland actually had reached, in the space of about 3 weeks, effectively elimination of COVID-19, which was obviously a fantastic outcome. And the implications of that was that without a real clear risk of community transmission at a high level, given the novel nature of the legal claims that we were making, it was considered that it wasn't appropriate to push that case to a final hearing at that time, also because the government had made concessions about protections for that individual client. So it was discontinued, but reserving his right to reissue if the situation and the risk profile heightened. But thankfully, as we all know since then, we've seen that in Queensland and throughout Australia now, the rates of community transmission have dropped effectively to a point of elimination. So we haven't had to re-agitate that case, but we still have not seen the substantive changes and protections and, to be honest, releases, which is the only thing that could happen that would mitigate against this threat in immigration detention nationally.
Great, thanks, David. And I think for our discussion, let's stay with the immigration detention context, and then we'll come back to the aged care setting and bring in John again before turning to our discussants. But David, I'm interested in hearing you speak a little bit more about what you see the relationship and the challenges between strategic litigation and public advocacy more broadly, that is calling for law reform or mass releases, versus strategic litigation, which is focused more on perhaps a particular client's story, or even in the case that you litigated, achieving, say, an order that applies to an individual client. Could you talk us through that relationship a little bit more?
Yeah, sure. So at the Human Rights Law Centre, our model is very much to combine very deliberate strategic litigation with public advocacy. We see them going very firmly hand in hand. So when it comes to client considerations, for instance, our situation is slightly different to the situation that San Marty was in, where she was approached by a client who asked to run this case. We were very much like, there is a legal case that can be run. Let's go find someone who wants to run it, who can be the vehicle to challenge this. And let's combine it with a public advocacy strategy. And I think these cases actually are a good example of the limitations of legal action without swaying public opinion as well. And I might just compare them to our work with the Let Them Stay cohort and the legal action that we took there. So very briefly, it would have been about 2014 or 15, were unsuccessful in the High Court case of M68 that was a challenge to offshore detention, and it was at a time that the government was seeking to return people back to offshore detention who'd been transferred here for medical treatment, including young children and babies that had been born in Australia. And following that case, we filed new proceedings in the High Court on an individual basis that argued that there wasn't a power to return them to offshore detention, and at the same time launched with GetUp and other key partners a massive public campaign, Let Them Stay, which called for the government to essentially not return these people who had been brought here for medical treatment. And the outcome of that was we've had more than 200 proceedings sitting in the High Court now for 5+ years in some instances, which the government hasn't actually litigated. And that was in part because the actual public campaigning there in that moment massively changed public opinion. We saw a 40% shift in public opinion in the space of 2 weeks, and the government expressly backing down on its threat to return children and families back to offshore detention. And as a result, we haven't had anyone removed for years now involuntarily. So in that instance, we had both a public advocacy campaign combined with, I guess, the stick of legal action that would have required them to fight multiple proceedings in the High Court. In this instance, we filed our case and we combined it with public advocacy, focusing not just on our clients' circumstances, but the broader group of people who are subject to this, as Salmati said, just punitive detention, that's the reality of what this is, and particularly at a point where there's the inherent risk to life from the virus. But in a time of a pandemic and in a time where people are quite isolated and very focused on their own circumstances, there wasn't the cut through in that public discourse. And there wasn't the generation of kind of public support for the government to do something different, which meant that really the change rested purely in the legal action. And as we saw with Salmati's case, even when it's successful, without the public opinion to stop the government stretching the boundaries of the law and appropriate action, you're left in a circumstance where the client isn't released into the circumstances that he should be released. So from our perspective, the legal action, and particularly duty of care tort legal action, is a safety net for the absolute worst instances on an individual basis. And you can run that in large numbers like we did with the cases to get someone from offshore to Australia. But it essentially needs to be, particularly in a space of refugee policy, which is a subject of such toxic political rhetoric, it needs to be supported by public advocacy and public support to create really lasting change that takes it beyond the fact of we can stop a child dying in a remote island to we can get all children off that remote island without them having to get to the point where a doctor says they've got 48 hours to live. In terms of balancing that with the individual client considerations as well, that's a constant difficulty in all strategic litigation. The reality is that, as we all know, lawyers have obligations to their individual client. So the situation is actually simpler once you have the client and you have instructions. What we find is that it's actually fairly rare that we are put in any position where the individual client's interest is particularly diametrically opposed in this space. The reality is that each individual client is after the same thing that the group is after in such a black and white area as refugee and people seeking asylum policy. But ultimately, where we do have instructions and they do differ to the broader interest, then we will always be guided by those instructions. And that's something that I think every lawyer is conscious of, and something that everyone who works in this space and who works in strategic litigation is actually really thorough about ensuring that they abide by those professional obligations.
Thanks, David. I think now's a good time to return to the case BNL 20 that Salmati ran. You've both spoken about the highly punitive framework and culture in which immigration detention operates and your clients find themselves. So Nati, in your case, even though you were successful, if you like, in being awarded an injunctive relief, an interim order, in response, the government lawyers in court said that in order to fulfill the terms of the order, they could potentially build a whole new immigration detention centre just for that one specific client in order to comply with the terms of the order. So I just want to invite you to speak a little bit more about how you navigate that highly punitive response from government, even when you find that you might have succeeded on the legal argument, and how you think about in the longer term, the sort of successes and failures of particular strategic litigation.
Yeah, look, that's quite right. Maybe because I didn't get to it in my rambling in the first section, maybe I'll say what happened in my case and who our client was. So he's a 68-year-old Pakistani man of Afghan origin. He had very unusual circumstances in that he'd been living very peacefully in the community for 10 years on a bridging visa with his Australian citizen son and grandchildren before his visa was suddenly cancelled at the end of last year and he was taken into immigration detention. So he had type 2 diabetes, a range of other health conditions that put him at extremely high risk. Also, what was unique about him as a litigant is his extreme risk appetite. He was the easiest person in the world to act for and a person of immense bravery and clarity of instruction. So it's unique to find someone who's quite like that. So anyway, as Sarah, you said, we were ultimately successful. There was a very definitive sort of judgment from Justice Murphy in the federal court declaring that the circumstances in MITA were comprehensively unsafe, that there were fundamental defects in the policies and procedures adopted by the Immigration Department and its contractors to manage COVID. And in that sense, there was a systematic or a systemic aspect to the interim judgment that sort of, I suppose, was lost in the surrounding media that sort of obsessively focused on the particularities of both MITA as a detention facility and the vulnerabilities of our client. So it was sort of individualized in ways that was deeply unfortunate. Anyway, with that background in mind, so then what occurred, because the terms of the interim orders were simply that the Commonwealth ceased to detain our client in that particular facility. Those were the terms that we'd sought. They're the type of orders that were granted in Medivac cases. It's simply that because in the Medivac cases, there were no other readily available facilities for detention, the result was transfer to Australia. In these circumstances, we knew, or the Commonwealth had dropped about a week before, the possibility of large-scale transfers of at-risk people to Yongah Hill Immigration Detention Facility. Then, of course, we know in yet another punitive move by the Commonwealth, Christmas Island was reopened last year to house the Billawella family from Queensland, the Tamil family, and they're being kept there alone. So Christmas Island was operational. We knew there were going to be these massive transfers to Yongah Hill. We knew, so we began to prepare for this second aspect of the litigation. So what happened is the orders were made within, I think, 48 hours that were provided to the Commonwealth. They declared that they were going to transfer our client to Yongah Hill. We then commenced separate proceedings in the Supreme Court of Western Australia seeking, of course, by that time, there were state border restrictions. So there was the granting of an exemption to our client without, of course, him seeking it, and without his input, without his consent and so forth. So we began a public law challenge to that exemption. And our argument was, and people who lose litigation, I'm sure say this all the time, it was a great argument, still available, very good. Bad luck, we lost it. But our argument was essentially that as a matter of basic public law principles, where you have an administrative decision that is of a character that affects the interests of a particular party, then that particular party is owed procedural fairness in respect to that decision, i.e. our client would have things to say and he wasn't consulted. Bad luck, we ended up before, on an interim basis, before a docket judge who couldn't or didn't chose not to grapple with that argument. And thought that it was a fait accompli that somebody who's detained has their utter, legal personality given over to their detainers. And so if they choose to seek permission to take them to a third place, then that was all legitimate. So, and that is where our client now is. He's being held in a special facility that's kind of like a cottage inside Yongah Hill, alone. I mean, bizarre way to, a bizarre and expensive manner, and he was flown there on his own in a charter jet, so no expense spared. Anyway, bizarre way to handle what was a situation that was clearly resolvable by his release into the community in Melbourne, in precisely the same house he'd been living in for a decade. Anyway, so, you know, to answer the kind of second question that was posed, you know, what makes strategic litigation successful? And I suppose, to my mind, what makes strategic litigation, as opposed to litigation per se, successful is the extent to which it's embedded within a broader movement, and to the extent to which it serves the goals of that broader movement. And in this case, that broader movement really is, like, let's not make bones about it, a movement to put an end to mandatory immigration detention in this country. And what I think was perhaps the failing of this litigation strategy is that it did not, or perhaps it did not anticipate how all-pervasive and universally, or how all-pervasive the concept of mandatory immigration detention is, how naturalised it is, both as a matter of public discourse, how it's accepted as inevitable, and it didn't sufficiently, the public strategy denaturalise that fact and go after the actual object, which was detention per se, as opposed to, you know, detention in one environment or detention under certain conditions and so forth. So I think that that strategies that private law strategies like this, or private law cases like this, need to appropriately identify their actual object, and there needs to be further movement building work that is brave enough and clear-eyed enough to talk about, you know, this is the same in the visa cancellation space, to be clear-eyed enough to talk about mandatory immigration detention being in itself a wrong and in itself an unacceptable feature of our system of law. So hopefully that addresses the question.
Yeah, great, Sanmati. And I'm sure we can draw out some of those key points in the discussion as well. So let's move now to return to the aged care context. And John, I wanted to ask you, so Sanmati made the point that that some of the harms that we saw in the immigration detention space are clearly structural rather than confined to a particular institutional setting or facility. And I'm interested in hearing you speak about that in the context of the litigation that you're running. So you're running legal action across 2 sites. And in Victoria in particular, we have seen these structural failures across aged care as a sector more broadly as well. So I'm interested in hearing you speak about to what degree you think the legal actions you're running can facilitate or move public opinion such that there is momentum for law reform, and how the legal actions you're running might be related to other initiatives that are currently on foot. You spoke briefly about the coroner's inquest and the WorkSafe inquiry. To what degree, as a litigator, do you see your actions directly sort of feeding into that shift or those other forms of accountability?
Yeah, thank you, Sarah. Well, I can tell you the genesis of the class action against St. Basil's and Epping Gardens arose out of the extensive media coverage whereby we have now nearly 900 people have died in Victoria as a result from nursing homes, as in living in a nursing home. Now, I saw, especially in July and August of this year, we were literally watching the news every night of people's loved ones dying in facilities, particularly in St. Basil's, where I think it's exactly 48 people have died. Epping Gardens, I think it's in excess of 50 people have died. I was watching that coverage, and I literally telephoned my partners and I said, this is just unacceptable. We've got to do something about this. I was receiving phone calls from the dependents of some of those loved ones at St. Basil's. The connection being I'm of Greek heritage. St. Basil's is owned by the Greek Archdiocese of Australia. 90% of the residents at St. Basil's are of Greek background, Greek heritage. We're talking, 80, 90-year-old residents who do not speak a word of English, Greek background, and I literally was receiving phone calls from the dependents saying, John, can you help me? My dad's dying in St. Basil's. I can't see him. I'm not allowed to, I can only see him through the window. Last week, and then the stories started coming out where there was no protection afforded to the residents. No, the PPE was not provided to the nurses working, the nurses and the home care attendants. The scale of the operational failures, once it comes out, you will be astonished. We're literally talking about private organisations that have cut costs to the bone to make profits. And as a result, we had the elderly and the vulnerable literally left to their own devices. And it became, the situation got so bad where, the dependents were telling me that I am taking in food for my mum, for my dad, on a daily basis to make sure they're getting fed, because guess what? They're not even getting fed. A lot of residents were left starving for days on end. And then on top of that, they were provided with food which was totally inappropriate, left on the table, and so they can feed themselves. And we're talking about the frail here. The scope of the systems literally broke down in especially these two facilities. Interestingly, there's, as you know, in Victoria, there's quite a lot of facilities. A lot of them didn't. A lot of them did not break down, and there's a lot of facilities, nursing homes, where COVID did not affect anyone whatsoever. Unfortunately, in these two facilities, there was an operational breakdown of a massive magnitude, to the point where the Commonwealth, and we all know this, the Commonwealth took over its operation on the 21st, the evening of the 21st of July, 2020. And even that takeover was shambolic, to the point where, well, basically at St. Basil's and Epping Gardens, especially St. Basil's, it got to the stage where the dangers of the virus had gone so rampant and throughout the home, throughout the facility, whereby even the staff, the carers and the home attendants and nurses were refusing to attend work. So we had the frail, the elderly residents sitting in their rooms by themselves for literally 2 days on end. One reason being the staff actually did not want to go to work because they knew it was too dangerous. The problem being the Commonwealth replacement staff had not commenced yet. And I've been told, and I've got witness statements which have been signed, whereby we have people that literally were left wandering the halls of these nursing homes freely, without no restrictions, and the dependents were coming and going to try and help their loved ones. Now, hence why the coroner has directed a formal investigation into the deaths of these people, as to whether or not the workplace, the Victorian manslaughter laws have been breached in any way, which only commenced in July of this year. And And the government and my legal advice is that even a minister of the Crown could be subject to prosecution if it's found that such reckless behaviour, and it's a bit more as the bar is raised in regards to workplace manslaughter in Victoria, as in you have to show not just negligent but reckless behaviour. So that'll be interesting to see whether or not such action would be proceeded with. We've got 2 class actions against 2 nursing homes. We have also a 3rd class action against the state of Victoria in regards to what happened with the second wave and the businesses that closed down and people that lost their jobs and businesses literally that have been closed down. And I don't know if you know Melbourne CBD at the moment, but it's still closed for business. We were only allowed as office workers to commence going back into the office as of last Monday. And that's only 25% capacity also. So Melbourne CBD is still pretty much closed, apart from some of the department stores where people are still going to spend their money shopping clothes as such. I'm not sure what else I can add to Sarah at the moment.
No, that's great. Thanks, John. And those stories of neglect in aged care facilities are truly shocking. And I think it goes to David's point that it was simply luck that there hasn't been a similar outbreak in immigration detention, given the risks posed to people in these closed institutional settings.
If I could just add, there's one other issue. As the Commonwealth did take over management and responsibility of these facilities in mid-July, there is an issue as to whether or not they should also be joined to these actions. At the moment, I've sort of left that as a wait-and-see approach because guess what? St. Basil's, the defendants themselves may join the Commonwealth to the proceedings. So that's we'll see.
Okay, interesting to watch. And in the discussion, we can discuss what the implications of that might be. But I'll hand it over to Claire now to introduce our discussants before we have a more open Q&A session. But thanks to all the 3 panelists so far for your great contributions and introductions.
Thanks very much, Sarah. Thanks, John, Sam Marty and David. And it's clear, I think, from the discussions that we're looking at both people who are living in these places that whose human lives are somehow accorded much less value than other lives, and that essentially the places they're living in are places of health risk, places that actually exacerbate health concerns and that warrant much more sort of oversight and accountability. And I guess what we've looked at so far is kind of the different legal actions that have been taken in each sector. What we'd like to turn to now is to get you, Stephen, to reflect on as another way of kind of bringing these harms to light. What is the potential for the Australia's OPCAT network to kind of bring about more accountability and reform in the sectors, and how might sort of advocacy around OPCAT, the Convention Against Torture, and this sort of kind of accountability and scrutiny that might bring sit alongside some of these legal actions.
Thanks, Claire. I just want to acknowledge that I'm meeting with you from the lands of the Darug people and pay my respects to their elders, past and present. So just to give a bit of context for those who aren't aware of what OPCAT is, it's short for the Optional Protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. It can simply be classified as the arms and legs of the Convention Against Torture, in the sense that it is a very practical UN treaty which Australia signed in December 2017. And what the treaty imposes is an obligation on Australia to allow for a dual system of independent, preventive, rights-based inspections to all places of detention in Australia, or to all places where people are or may be deprived of their liberty. And I'll go back to that point because I think it's pertinent that we talk about what that constitutes. So the first level of accountability is visits, periodic visits from the UN Subcommittee for the Prevention of Torture, or the SPT as it's commonly referred to. And this is the UN treaty body, which is made up of 25 individual members, experts from countries that have ratified the OPCAT, and they're elected to membership, and they conduct visits to countries, have full access to all places of deprivation of liberty, are able to talk to anyone in private, able to speak to staff, and enjoy full access to all information contained within a site of detention. They then make a report on their findings to the government, or governments in our case, and the government, of course, is expected to respond to those findings. Obviously, with a preventive mandate, what they're looking at is, of course, preventing ill treatment and torture from occurring, but in addition to identifying practices that can constitute ill treatment and torture. So it's very broad in the sense that it can look holistically at healthcare. It can look at mechanical restraints. It can look at the use of solitary confinement and isolation. It can look at transport. So it has a very broad preventive aspect to it that looks at the system holistically and draws on information, and not just from people who are detained, not just from officials, but from civil society, from visitors, from other oversight mechanisms, and triangulates all this information to be able to provide a very informed view of what's happening in a site of detention. So the unfortunate part about the SPT is that due to their limited capacity and limited resources, their visits to, say, Australia would occur once every 5 to 10 years. So in that sense, that's probably not the exciting part of the treaty. It's not the more useful part, although this, the SPT did intend to visit Australia for their first visit in March, April this year. But of course, due to COVID restrictions, they've had to postpone that visit, and hopefully they'll be able to conduct their visit next year. So getting to the second of the obligations is probably the more important obligation, is to establish a national preventive mechanism, or an NPM. The NPM is a domestic oversight mechanism which conducts the same sort of preventive visits to places of detention. So in regards to Australia, Australia has an obligation to set up this NPM, which it has decided will, because of the the federal nature of our country, will include bodies that have oversight of states and territories, and a federal body looking at federal places of detention and coordinating this network of NPMs. So at present, the Commonwealth Ombudsman has been designated the coordinator of the NPM network, and also the body responsible for oversight of federal places of detention, which includes immigration detention, federal police custody, and Australian military detention. So immigration detention was, of course, no stranger to the Commonwealth Ombudsman. They have had for a number of years conducted oversight of immigration detention, but with an administrative lens and not a human rights lens, which is obviously a huge difference. In terms of states and territories, I suppose I need to add that at ratification, Australia decided to utilise Article 24 of the OPCAT, which delays the commencement of the NPM for 3 years on top of the 1 year. So Australia's obligation to have an NPM is in place, effectually has to be in place by January 2022. So they're in the final year of preparation for an NPM, and has, of course, made very little progress in regards to establishing this network. So as I mentioned, besides the Commonwealth Ombudsman at the federal level, Western Australia has designated 2 existing bodies as its NPM. So the Inspector for Custodial Services, which as many know, has a remit over prison and youth detention and court custody. Its designation will expand its oversight to police custody within Western Australia. And the other body is the Western Australian Ombudsman, which will have responsibility over mental health facilities and forensic disability facilities. While this Western Australian government has designated these bodies, it's provided no additional funding as yet. In fact, the inspector has had a funding cut in the recent budget. and no legislative changes to enable these inspections. In Tasmania at present, there's a bill being debated regarding the Tasmanian custodial inspector having to being the sole MPM for Tasmania, which will mean that it will expand its remit to include mental health facilities and forensic disability facilities and police custody on top of correctional facilities. South Australia as well has a bill currently being debated, which will introduce a new body, which will be an official visitors body for prisons. Which you know, if you've had a look at the bill and had a look at the requirements of OPCAT in its current state, is woefully inadequate to meet the requirements of OPCAT and doesn't meet it. So that's something that my network has been working with and had several discussions and briefings with members of opposition and the crossbench, trying to get changes to that legislation. So that is really, in essence, where we're at. So all the other states and territories haven't designated a body. They haven't had public consultations on a body. So they're really leaving it to the last moment to designate their bodies, which is very unfortunate because, as international experience attests to, you know, an MPM is not just rebadging an existing oversight body and thinking that's sufficient. It requires a lot of stakeholder education. It requires working practices and memorandums of understanding between oversight bodies, and it requires prioritization of work. So that's where it's at the moment. Probably going back to the idea of deprivation of liberty and what that means in an international context, this is probably the most controversial point of Australia's ratification, is that the Australian government has decided that it will have a focus only at this point on what it calls primary places of detention. So that's police lockups, military detention, immigration detention, prisons and youth justice, mental health facilities, and forensic disability facilities. That is a practice which no other state who has ratified OPCAT has undertaken, and there's nothing in the OPCAT that allows that. There's nothing in the international literature that supports that. But the government has taken a position that it wants to focus primarily on the places where the most harm is at. So using the idea of proportionality, it wants to focus on those places to the exclusion of what I would term non-traditional places of detention, including aged care, disability, group homes, special schools, and other settings where confinement occurs.
So just perhaps, Stephen, if we pause at that moment, because I think there's a lot we can perhaps discuss in the final the Q&A session, because I think that raises really important concerns. It provides a good introduction to Claire Spivakovsky's work on disability and deinstitutionalisation, and the way that, you know, in particular those with disability and others in aged care are sort of escaped from the remit of the preventive mechanism. So thanks so much, Stephen. I'll just lead into Claire in the interest of time. So Claire, you've done extensive research on experiences of living in disability care homes and on the need for deinstitutionalisation. Can you talk a little bit about what you see as a contribution of academia to strategic litigation, and also how we might think about these spaces more generally in terms of a bigger picture of reform, deinstitutionalisation, or even abolition? So I'll just hand it over to you to respond to some of those concerns. Thanks.
Thanks so much, Claire, and hello to everyone. I'm coming to you from the unceded lands of the Wurundjeri people of the Kulin Nation, and I'd like to, of course, pay my respects to their elders, past, present and emerging. And I got given a very large question, and I'm going to attempt to answer it however I can answer it. And in part, I think I'm going to build a little bit on what Claire started us off with at the beginning of the talk, but also picking up on some of those sorts of issues, or at least in my head, I think they intersect with some of the issues we've already been discussing so far in the panel. So in essence, I kind of want to answer this question in two parts. So what has been the contribution of academia to sort of thinking about spaces of confinement so far, and what could be the contribution of academia moving forward. And in terms of what has been the contribution so far, I think it's been a little bit uneven. And by that I mean significantly more work has been produced in the context of immigration detention than it has around aged care or indeed any other space of confinement, such as disability group homes that myself and Linda look at as well. And I think it's important to consider why that might be the case, because I think that tells us a little about what the contribution has been and what it could be moving forward as well. So if we want to do that, if we want to consider why there is this kind of uneven consideration of immigration detention spaces versus aged care spaces versus disability spaces when it comes to thinking about spaces of confinement, I think it's worth asking two other questions, which is what makes it easier or more likely for academics to consider a space like immigration detention from the context of confinement, and conversely, what makes it harder or less likely for academics to consider spaces like aged care or disability group homes in this particular way. And while I'm obviously not the bearer of all academic knowledge, I do think it's still fair to speculate that one of the reasons why immigration detention spaces have been more heavily attended to by academics is because they share so many of the kind of characteristics with that primary space of confinement, which we're most familiar with, which is the prison, which is the point I think you're also saying, Stephen, about the ways that it's understood as being specific kinds of spaces. And I think this has been also one of the key contributions of academia to thinking about immigration detention as a space of confinement. And by that I mean what has been offered by scholars who draw these lines between prisons and immigration detention is not just the simple observation that immigration detention centres look like prisons, are generally operated by the same folk who run prisons, are generally run by the same private operators who run prisons. But rather, I think what academia offers to this space is the more complicated observation that despite essentially looking the same and running in a very similar fashion to prisons, immigration detention centres do not seek to achieve the same ends. And I think this is also what our panel was speaking about earlier today. That while we sort of have in theory this idea that prisons are about rehabilitation and reintegration of those who pass through their walls, there's no such fallacy of return around immigration detention centres. That these are places where people are held for the purposes of immobilisation until they can be kicked out of communities and country. That these are places where life is put on hold, where it's put on standby, and where it cannot continue to flourish. And so what I think has been the main contribution of academia to date is this appreciation that while we have always known to some extent that certain spaces of confinement look alike or can be timetabled in a similar fashion, what we really need to pay attention to is their ultimate objective in these spaces, that sitting behind very similar looking facades are quite different beasts. And yet at the same time, I also think what academia has started to sort of gain from thinking about immigration detention in relation to prisons in this way is the opportunity to think about that in reverse as well. And by that I mean, in seeing that sitting behind very similar facades are very different beasts, I think academia can offer us the possibility to consider if and how different looking beasts can in turn bear troubling similarities. And this is where I think we start to get an answer to that other question that I posed before about what might make it harder or less likely for academics to consider spaces like aged care, and I'm going to continue to add disability group homes into that as spaces of confinement, and also that question of what could be done in terms of the contribution of academia moving forward. So if I can explain myself a little bit better, in essence, what I get excited about is the work that is coming from excellent early career researchers like Claire Lonan into aged care, or like Linda Steele into disability spaces, or even if you give me the grace for a moment to toot my own horn, I think also my own work sometimes, into this kind of understanding that we are mistaken sometimes in our belief that prisons offer the blueprint from which we can and should identify all other spaces of confinement. That while places like nursing homes or disability group homes don't on the surface look like prisons or immigration detention centres, they can, behind their much smaller closed doors and much smaller contained walls within the community, perpetrate very similar harms and violence. And I think this is what we've already started to hear on this panel. And that for too long we've overlooked these spaces because we've simply thought of confinement in terms of physical dimensions, that we have assumed that what defines a space of confinement are characteristics such as tall walls, segregated dormitories and wards, barbed wires, or the classic of a good old lock and key to a cell. But what I think we are starting to gain through the kind of excellent work of scholars like Linda and like Claire is an appreciation that nursing homes and disability group homes are not just spaces of confinement, but are rather multi-layered sites of confinement and control that contain people through sight of place and through sight of body. And since I'm pretty sure that's an opaque thing to say, I'm going to try and have another stab at it, which is what I'm trying to say here is that we limit ourselves when we think of prisons and immigration detention centres as the blueprint from which we can identify all other spaces of confinement, that we in essence miss out on realising that aged care and disability care homes are capable through law and their very targeted provisions to contain people through the physical site of the home, through things like environmental constraints and through things like seclusion, but also then through the physical body, through things like mechanical and physical restraint made possible in disability-specific and aged care laws, and all through the incorporeal site of a person's mind, through the chemical restraint that we hear about over and over again in both our disability and aged care royal commissions, and yet we still allow to persist. And so to me, I think what we gain when we begin to realise that spaces of confinement that can look dissimilar in physical characteristic, but can still be identified through practices of segregated containment and control, is this opportunity to bring the wealth of knowledge and conceptual tools that have been developed by scholars in these different spaces together. And so for me, that offers three hopes for what academia can contribute moving forward. And I'll run through them very quickly if I have time. Claire, do I have time?
Just very, very quickly, yeah, and then we'll move straight on to Q&A. Thank you.
No problem. So in essence, the one thing that I think academia can do moving forward is offer that excellent vocabulary that we have about what does it mean to have legitimate spaces of confinement, or indeed illegitimate spaces of confinement, and what is state crime and state corporate crime, and what do we do in that space. I think what we could also add moving forward is the kind of amazing work that's being undertaken by scholars like Leanne Weber into internal borders, and the recognition that spaces of confinement are kind of on the landscape, these crunch points that pop up, but we're realistically talking about never wanting particular parts of the community to ever flourish across all time, across all space. And these are just kind of the endpoints where we filter them. And I think, and this is the sort of work that Linda does as well, what I really hope we start to realise and move forward, and what I think academia can offer around that strategic thinking, is the connection between these spaces. Because the thing that I often so fear is that when we talk about how do we dismantle something like the prison or immigration detention, we often rely on narratives about the poor person who's in physical or mental or medical distress. And that's very, very true. But those same narratives that we use about that and the recourse we do to go back to the community, to go back to support, to get these things for people, those are the same narratives we use to install aged care and disability group homes and keep them in place. And I think we need to be able to see that connection, and that's what academia brings. So thank you for letting me get that out.
Thanks very much, Claire, and thank you. Wonderful, reflections from your perspective, Stephen's perspective from through the OPCAT network and the role that does, and I think it follows on really beautifully from David, John, and St Marty's presentations. And I just want to, before I hand over to Q&A, which Linda will moderate, I just want to go back to St Marty's point about this sort of colonial logic, and it's important to reflect on the way that Australia was founded on a system of reserves, missions, and quarantine stations, and that is deeply embedded in the way that we exercise control. And I think we can also see that level of control play out well in some respects for COVID, but badly for others. And as we know, many of these sites are also places of kind of racialised, ableist and ageist forms of oppression, and those kind of attention to race, ageism and ableism is really important to hold on to here. So I'm going to hand over to you, Linda, if you can moderate the questions, but thanks very much for the great contributions from the panel.
Thanks, Claire, and thank you very much to all of our panelists for such fascinating reflections across legal practice, activism, and academia. Does anyone have any questions? There aren't any in the chat. Feel free to raise your hand, or you can just start speaking. And if we have too many people speaking, I'll put you in order.
I just had, sorry, this is Savitri Taylor. I had a question for John, actually, because he said that the St. Basil's was owned by the Catholic diocese, or the Greek Orthodox diocese.
Greek Orthodox,
which automatically, to my mind, seems to say not-for-profit good people, but clearly, do they run St. Basil's as a for-profit? Because I think when we talk about privatization, we talk about a profit motive, and then we put them into one basket, right? And then which is different from the not-for-profit.
It's a non-for-profit organisation. However, as we all know, there are certain organisations that still, even though they're not for profit, they still want to maximise their own profits, so they can themselves expand land holdings as such. And the Greek Archdiocese has, I know for a fact that $2 million out of the profits of the St. Basil's nursing home was used to purchase a $6 million penthouse for the Greek Archdiocese in Sydney Harbour. So, which again is all for charity and non-for-profit, but it's in aid of the actual organisation. On the other hand, Epping Gardens, that is not a not-profit organisation. Certain directors own that entity via various companies as such, and so that's clearly a profit-based organisation.
Great. Thanks, John. Oh, so sorry, Svitri, did you have?
No, just to say thank you.
Thank you. Does anyone else have any questions from the audience? Okay, well, I'll let Claire ask her question then. Claire.
Oh, it was just in case no one was jumping in. I just it's more a comment. Alexandra put in the chat that the High Court decision on the Nauru case has been handed down today. So perhaps it might be helpful if David and St Marty are able to comment on that High Court decision that was just released over half an hour ago.
Yeah, sure. I'm happy to comment on that. It's been a whirlwind of messages in the background of this presentation. I haven't read the judgment because I think it came out as this conference started, but my team has, and my understanding is that the ABC reports are incorrect in the actual implications for that case. That case is a really good example of the lengths that the executive will go to in this space to frustrate legal action. Essentially, it was a challenge to, we filed a whole range, along with sector partners, a whole range of cases in the federal court arguing a breach of duty of care because of a failure to provide medical treatment. There's a section in the Migration Act which its express purpose is to prevent litigation by people who are subject to offshore detention to the greatest extent constitutionally possible. So it seems like the government wanted that section to mean that a proceeding could only be filed in the High Court. They raised that in arguing that the federal court didn't have jurisdiction to hear these cases, despite the fact that the only implication of that section would be that we would file in the High Court and then be remitted back to the federal court. So there's no practical benefit, something that the Commonwealth expressly recognised in its arguments in relation to this case. It seems that the High Court has allowed the Commonwealth's appeal, but on a different ground. So what they have said is that the sections in the Migration Act don't actually affect the jurisdiction of the federal court. The court still has jurisdiction to hear those cases, but these provisions can be pleaded as a defence by the Commonwealth if it wants to. Although the High Court did note that if the only purpose of pleading that defence is that it goes to the High Court and then is remitted to the federal court, that may well be inconsistent with the Commonwealth's model litigant obligations, which, while sadly is not something that often governs their litigation conduct in this space, potentially express statements from the High Court regarding that may influence their action, but that will remain to be seen. So my understanding is that the actual substantive point is still to be determined as to whether those sections apply, but it does not prevent the current federal court litigation from continuing at this point.
Okay, thanks, David. Does anyone have any other questions at all? I just had one, if I might, just for John. My understanding is that the class actions against the two aged care facilities don't only have within the class residents or deceased residents, but also family members and also employees. I was wondering if you could just briefly talk to that and I guess more broadly how that grouping of interests might kind of shape our understanding of what the wrongs are or where accountability lies differently.
Yes, thank you, Linda. Well, yeah, in clarification, the claims relate to those people that have either died or been injured or affected in any way arousing out of the conduct at these facilities and the impact of COVID-19 in that regard. So we've got there is a mixture. We actually do act on behalf of quite a few staff, care attendants and nurses that were working at the time at Epping Gardens and St Basil's. They have lodged separately their own work cover claims. All have been accepted. There's a directive by the state government that all claims as such initially will be accepted and probably re-looked at in 6 months' time, but at the moment they've all been accepted on a preliminary basis. And so they've got their own work cover entitlements, anyone that was working there. Then under the Wrongs Act, these proceedings have been issued for anyone that has suffered psychological or physical injury as a result of the actions that has occurred due to the mismanagement and the COVID-19 situation. And that can include loved ones, dependents, even grandchildren, for example, of their loved ones that have died at these facilities. And then, so that's their claim for psychological injury and or economic loss claims if they haven't been able to work, for example, due to the stress and anxiety that they have suffered as a result of these actions. And of course, there's pain and suffering damages there too. And maybe aggravated damages or exemplary damages, in the sense that we say initially, down the track, the submission will be made to the court that due to the nature of these injuries and the conduct thereof, that exemplary damages are appropriate. Of course, that's a matter for the court to decide, and that is open under the Wrongs Act. It's precluded under the work other claims, but it is open under the Wrongs Act, in essence, public liabilities claims, for exemplary damages to be awarded.
Great, thanks, John. Thank you. And I just had one other question come through in the chat to Stephen. I was wondering if you could perhaps briefly reflect on the status of aged care facilities under OPCAT, and perhaps across the two sites, then also just mention what you think the connections are between OPCAT monitoring and litigation strategically. Are there any connections that can be made?
Yeah, sure. Well, as I mentioned before, the government's position is that aged care doesn't come under their responsibilities for OPCAT. I think they went into the ratification not knowing that aged care was a function that they need to look at. So in Senate estimates in 2019, when questioned about whether aged care would be included, they definitively said that they do not consider aged care as a place of detention. Obviously, there's been a lot of advocacy since then. You know, there are Senate reports which describe practices in aged care as detentions. There are court matters which have shown unlawful detention in aged care facilities as a form of civil detention. And of course, the practice internationally, aged care facilities are visited by oversight bodies who have ratified OPCAT. Most notably and most recently, our neighbours in New Zealand, who over the space of the COVID outbreak have made visits to aged care facilities. I think sort of touching on what Claire was talking about, I think it's really difficult for the public to conceptualize aged care and disability as places of confinement, because I think it really, in order to do that, we have to grapple with you know, social consciousness, this element of guilt, that, you know, it's okay to send people to prison because they've done something wrong, but to put someone in a place of confinement because of who they are, there's an element of guilt to that I think everyone is uncomfortable with. But I think the Royal Commissions are really opening up, you know, people's eyes to that possibility, that conceptualization. You know, for instance, the interim report of the Aged Care Royal Commission described the system as lacking accountability, reporting, lacking, it described it as cruel and harmful. And, you know, I think as a result of that, people are more open to the idea. And consequently, we've been seeing a lot more progress in trying to get aged care under OPCAT. So just this year, again, in Senate estimates, asked the same question whether aged care would be prioritised. The government didn't say it was no, you know, it dropped the whole, it's not a place of detention, and rather just said it's not a place we're going to prioritise. They said that in May 2020. And, you know, just as a sideline, in the 3 months until May 2020, there were 1,331 reportable assaults in aged care. So how they cannot see it as a place of prioritization, I don't understand, but that's their decision. But we'll continue working as a network and with others to call for changes to that, to have it included. And in regards to the question about litigation and oversight, I think they go hand in hand. And I think the current test case in the federal court that the Public Interest Advocacy Centre has regarding the handcuffing of an asylum seeker is a perfect example of how that occurs. So, you know, PIAC has built a case and built evidence on the preferred position of Home Affairs and Serco to handcuff people as a first response and not a last resort. And that has been strengthened as, you know, if you just look at the media articles about the case, it's strengthened by the fact that just this year, the Commonwealth Ombudsman produced a public report as an OPCAT body to state the same thing about its concerns about those practices. And of course, the Human Rights Commission has for a long time made public statements about those practices. And I think, you know, the fact that the Commonwealth Ombudsman has a public report is a testament to how important OPCAT is, because as many of you know, it did not produce any public reports about immigration detention prior to OPCAT ratification, but has now, as a requirement of OPCAT, has begun producing those reports. And of course, those reports for you know, for the legal sector provide an independent expert assessment of the conditions of detention, the treatment, and the procedures by which you can launch these cases. And in the same way, litigation is a reference point for oversight bodies to argue or to question practices in detention that they may not have been aware of, but may only be there, but may only be part of their awareness due to the fact that they're high-profile cases. So I think there is a definite connection there, and I think more lawyers need to be aware of OPCAT and be advocating for its full implementation.
Great, thanks, Stephen. We're nearly out of time, so I just wanted to finish by returning to the lawyers who started us off and have very much provided the inspiration for today's panel, and just ask if they had any very brief closing remarks. And Marty, did you have anything you would like to say in closing?
Yes, thanks very much. It's all been really fascinating. And I suppose one thing I wanted to observe is maybe that perhaps, you know, something to think about is not only, you know, these kind of conceptual separations that we practice between different forms of confinement, but also perhaps the sort of disciplinary silos and the boundaried ways of thinking between different disciplines. So, you know, it's not an exclusive inside of academia, for instance, that there are strong similarities between forms of confinement, right? So this is something that lawyers practicing within the framework of the law, albeit, you know, despite its confinements and despite the limitations that we've talked about, and despite the kind of disciplinary frameworks that we operate within that are really finite, this is something at the forefront of our minds, and it's not the exclusive province of academia to sort of bring those connections to the fore. So for instance, working in immigration detention, our clients have often experienced all of the various forms of, except of course, you know, state-funded and state-provided aged care, but they've often experienced all of the other various forms of incarceration and detention. So you have folks who come from custody, they then enter seamlessly immigration detention, then because of their conditions in immigration detention, they're then outsourced to you know, sort of involuntarily being held in a hospital setting, you know, under the Mental Health Act. And so, and they're seamless. I mean, the contractors who are operating in one area, Serco is just this invidious contractor. I mean, these folks run council facilities. Their names are on my local bins. Like, you know, so it's, I suppose perhaps a role for all of us to think about is how it is that we can articulate what it is that we do in our finite different silos in the broader language of movement. So in the broader language of what it is that we're trying to achieve, without sort of assuming that there's any one component of that picture, or there's any one silo of people doing that work who are more apt to do it in a meaningful way. You know, we operate in a place where since 1992, it's a bipartisan consensus that immigration detention needs to be mandatory. You know, our inroads to that have been, as a matter of law, really minimal, but as a matter of public, as a matter of public discourse, and also as a matter of academic discourse, our discourse, you know, like Claire said, makes inroads into that concept in language that kind of fortifies the concept. For instance, innocent people are being held in immigration detention. Sometimes people who are not strictly innocent are being held in immigration detention. They still oughtn't be detained. You know, so sort of I suppose it's all of our responsibilities to articulate specifically what it is that we're doing in a language that's broader than any of our disciplines and in service of a movement that's bigger than any of our disciplines. And that's been a really fruitful insight from today's discussion. So that's what I would have to say.
Great, thanks so much. And yeah, that's certainly a really important place to finish in terms of thinking about how we can all work together and amplify the important activism and legal work that's being done, and how the Academy can support that as well. And thank you. David, did you have any concluding thoughts?
Sure. I might even just very briefly pick up San Marty's point, because I think that is really the key issue here, is that we live in a world where detention is entirely accepted and considered inevitable, when we know that it is an entirely arbitrary invention, as hard borders are in the 21st century as well. So I think what I've really enjoyed of this session is that opportunity to bring together the different disciplines, given that legal action can only get us so far and really is just that stopgap. But legal action combined with activism and combined with the ideas that come from academia are really the driving force for change. And I think too often our progressive movement is focused on what we're against and what we're trying to stop happening. And that's because, particularly in the refugee space, we're facing an onslaught of ever crueler policies by the government. But we really do need to be able to articulate both the vision of what Australia can be and what the world can be, and the fact that the current state that we're living in is in no way inevitable. So collaboration between these different disciplines is so vital, and it's been great to hear from different perspectives today.
Thanks, David. Thank you. And John, did you have any closing thoughts?
Thank you. It's just interesting to note the correlation similarities between nursing homes and migration detention facilities. It's almost scary, actually, because initially you wouldn't think there should be any similarity and correlation, but unfortunately it seems, facilities as such, and especially when there's Commonwealth and state oversight, well, the paradigms merge. One thing I could raise with and the migration issues that have been raised today and the detention issues, they've been around for years. When I was a young lawyer, nearly 20 years ago, I call him a friend of mine, Eric Vidalis, was involved in the Tampa case, which you probably all recall back 20 years ago, which influenced the Commonwealth election. And that was, nearly 20 years ago, 18 years ago from recollection. And the same issues resonate, almost on a weekly basis. And not a lot has changed, unfortunately, in this type of policy over the years. And the issues still keep coming up again and again, and they're similar issues. And on a totally out there thought, I was watching an old West Wing episode from 2004 just the other day, and again, the issues of migration and going from one country to another, and countries raising issues about migration. It's something that hasn't gone away, hasn't been fixed, and unfortunately, it seems like it's still going to be an issue, and it's up to us. We're all passionate advocates for our clients, and it's up to us to keep on fighting the good fight.
Thanks, John. And I think that's a good positive note to end on. So we'll finish up there. I know some of you are either presenting or registered to listen in to the next session in another Zoom room. So thank you so much to our panelists, John, San Marty, David, Stephen and Claire. And thanks again to Trish and the Lausanne's conference team for making this event happen, and to my co-facilitators, Sarah and Claire. You And if you feel free to get in touch with us if you have any further questions for the presenters, we can always pass those on to them. Thank you very much.
Thank you.